the Supreme Court put it very succinctly in the case here that by the name of the doctrine. It's the Frisbie v. Collins case. And they stated in that case, there is nothing in the Constitution that requires a court to permit a guilty person rightfully convicted to escape justice because they were brought to trial against the will. They're against his will. And the doctrine so far has survived 140 years of challenges. But this is going to be the one, as you'll see why in a minute, that could be the one that could break the mold here and dent that armor. Now, it began in 1886 with the Ker-Frisbie, Illinois case. The doctrine began when Frederick Kerr, he was a U.S. citizen living in Peru. He was wanted on charges of larceny and embezzlement. And President Chester Arthur sent an agent to Lima, Peru, with proper papers to negotiate Kerr's extradition through official channels. However, the agent didn't want to wait. So instead of processing the extradition, he kidnaps Kerr, brings him back to the United States by force. And Kerr argued that the abduction was illegal and that the court therefore had no jurisdiction over him. Supreme Court disagrees. They said such forcible abduction is no sufficient reason why the party should not answer when brought within the jurisdiction of the court, which has the right to try him for such an offense and presents no valid objection to his trial in such court. Meaning, it didn't matter how he arrived. That's something separate that can be dealt with through, the agent who might have done something illegal or international law, whatever body wants to deal with the people that did it. But the fact that he's there, once he's dropped off there and he's in custody, he's not going out of custody. The holding was clear. It didn't matter. Then we had the Frisbie v. Collins case. That's a 1952 case. 66 years later, Shirley Collins is living in Chicago when Michigan authorities decided they wanted to try him for the Big Red Rum. Rather than go through proper interstate procedures, Michigan police cross state lines and they forcibly bring Collins from Illinois and bring him back to Michigan to stand trial. Collins is convicted. He's sentenced to life in prison. And he files a habeas corpus petition. And he argues that his kidnapping by state authorities violated the 14th Amendment's Due Process Clause and the Federal Kidnapping Act. Now, Justice Hugo Black, who is the Supreme Court, who is I believe Black was the head of the Supreme Court at the time. He's writing for Supreme Court, rejects the argument and reaffirms the Kerr finding. This court has never departed from the rule in Ker v. Illinois that the power of a court to try a person for a crime is not impaired by the fact that he had been brought within the court's jurisdiction by reason of forcible abduction. They rest on the sound basis that due process of law is satisfied when one present in court is convicted of a crime after having been fairly apprised of the charges against him and after a fair trial in accordance with constitutional procedural safeguards. That's Frisbie v. Collins, 1952. The court went further and addressed the Federal Kidnapping Act might provide an exception, but it concluded that the severity of the sanction under the Federal Kidnapping Act made it unlikely that Congress intended them to apply to law enforcement officers. So the conviction stood. Then we get to the case of, we go to 1992, right? United States versus Alvarez-Machain. This is one of the most important tests next to the case that's coming from Maduro. And it involved DEA agents. It involved the DEA, Mexico, and allegations of the Big T and the Big Red Rum. Look on the screen and you'll see what I'm talking about, okay? Humberto Alvarez-Machain was a Mexican physician allegedly involved in one of the most brutal crimes against a U.S. law enforcement officer in history. I'm not going to get into what happened. You can see it there. Go to the website. Go to justiceisaprocess.com. You can read about what happened. But it's brutal. It's terrible. And they believe that Alvarez-Machain participated in this act. When negotiations for Mexico for extradition failed, the DEA took matters into its own hands. And on April 2nd, 1990, Mexican nationals hired by DEA agents kidnapped Alvarez-Machain from his medical office in Guadalajara, flew him in private plane to Texas, and handed him over to U.S. authorities. Now, the Mexican government lodges a formal diplomatic protest. The district court dismisses the indictment, rules that the kidnapping violated the U.S.-Mexico extradition treaty, because there was an extradition treaty between U.S. and Mexico. The Ninth Circuit affirms it, meaning they agree. And then the Supreme Court reverses it, with Chief Justice Rehnquist writing for the majority, acknowledging that the abduction may be in violation of general international law principles, but he noted that Mexico had protested through diplomatic channels, but he concludes that the extradition treaty did not explicitly prohibit kidnapping and therefore could not be read to prohibit it. You can't read crazier stuff, but they're saying it didn't deal with that. So Justice Stevens writes a blistering dissent, and he's joined by Justice Blackburn and Justice O'Connor, and he argues that the decision encourages governments to engage in additional acts of international lawlessness. And this is exactly the thing that we have to be concerned about in what happened here in this case. That yes, when governments engage in this type of behavior, it opens the door for future behavior. It opens the door for other nations to do the same thing. And that's what we have to protect against. That's what we should be operating under. We are the lawful. We're not the lawless. So when we do things like this, we become the lawless. And it's very dangerous because it sets the precedent. Because if we're not willing to learn by the law, who is? You've got leaders out here that don't care. We're supposed to be the shining example that we can do things lawfully and get things done correctly. And, that was what those three justices said. But here's the twist. Despite the Supreme Court ruling that the court had jurisdiction, Alvarez-Machain was actually acquitted. Not just acquitted. He wasn't even acquitted by a jury. The trial judge, and this is so rare, you don't see it at all, happen very much, that they ruled that the government didn't even make their prima facie case, meaning in the light most favorable to the government, the evidence that was presented was so weak, it didn't even meet that standard. And acquittal was granted before sending the case to the jury, which is unbelievable. And then we have the Noriega precedent. Now, this is where President Trump and his team are believing they have their authority to do what they did. They're citing this 1989 invasion of Panama. I'm sure some of you, I remember my dad telling me about this. This is something my dad was all up in arms about when it happened. And it was a prosecution of Manuel Noriega and it's very similar to how this all went down. And it is inside of this that you're going to understand the defense that Maduro will plan to put up. On February 4th, 1988, a federal grand jury indicts General Manuel Antonio Noriega, the de facto leader at the time of Panama, on drug trafficking charges. The indictment alleges that Noriega had exploited his position as commander-in-chief of the Panamanian Defense Forces to assist and protect international drug traffickers, including the Medellin cartel, in exchange for personal payoffs. For nearly 2 years, Noriega remains in power in Panama. He defies U.S. demands that he step down. He annuls national elections in 1989 when international observers said he lost. And he declares hostilities against the United States. And again, all of this, I think, is known because he's trying to avoid losing what he thinks is the only thing keeping him from being prosecuted, which is something Maduro thought he had, and you're going to learn about what that is. On December 20th, 1989, President George H.W. Bush orders the invasion of Panama. And the stated purpose was for safeguarding American lives, restoring democracy, preserving the Panama Canal treaties, and seizing Noriega to face federal drug charges. They unleashed 27,000 U.S. troops down to Panama. Noriega initially evades capture, but eventually takes refuge at the Vatican embassy. And U.S. forces surround the building, and then now, I remember my dad telling me about this, they blasted rock music to pressure him into surrendering. And on January 3rd, 1990, all right, you think it is absolutely no accident that